of which means I know anything about re-examination or reply, other than what I'm going to tell you. These are two related topics, but have some differences. Re-examination refers to the questioning counsel can do of a witness after that counsel is called after the witness has been cross-examined. It's an important tactical decision to make whether to conduct a re-examination, and it's interesting to note that some of the great counsel of the past have really differed on whether it's a wise tactic to pursue. John Sapinka, who was a wonderful trial lawyer before he decided to spend the rest of his career slumming on the Supreme Court of Canada, was a great fan of re-examination because he thought this was a way of getting the last words of the witness before the judge, with the lasting effect that would have, and getting the witness to say some things that wouldn't be subject to cross-examination. And he actually was a fan of planning an examination of a witness so that the cross-examiner would actually raise some new points, leaving them for the cross-examiner to raise in some way that would allow him in re-examination to then lower the boom with some terrific new disclosure that would come out. Walter Williston, another counsel of legendary proportions, thought that re-examination was tactically unwise in most cases because the way you have to conduct it is, first of all, to draw the witness's attention and therefore the judge's attention to some harmful evidence that was given in cross-examination. You remind the judge of that, the way you remind the witness of that, then the witness normally will go ahead and repeat it a few times to remind himself or herself of it, all indelibly imprinting it on the mind of the judge and making things worse rather than better. Now, what makes the tactic so difficult is our law society rules don't allow us to talk to your witness after cross-examination before you re-examine, and therefore put you in the position of sort of the Zen archer. You have to hit the bullseye blindfold. So it's a difficult tactical decision to make, and what often adds to the difficulty is many counsel, me among them, will say to the witness when you're preparing them initially, well, here's what's going to happen. I'm going to question you, and then you're going to be cross-examined, and then if there's a problem that's come up on the cross-examination, I may re-examine you. Well, when you get up to re-examine, the witness goes into blind panic because although they may not have known or may not know what you're after, all they know is they said something wrong. So who knows what will happen when you ask the questions. Well, assuming you get over all of that and you decide to do a re-examination, what can you ask? The rule is you can only ask about new matters that have been raised in cross-examination for the first time for the purpose of clearing up confusion or ambiguity. So let's take a brief trip down a list of some things you can do in re-examination. If some discrediting facts have come out on cross-examination for the first time, the cross-examiner establishes that on the same facts the witness made a plea of guilty to a provincial offense, then you can bring out in re-examination the reasons why. You can explain those discrediting facts, that it was an expensive charge to defend, the fine wasn't very big, it wasn't really an admission of guilt. You can ask the witness what certain words that he or she used in cross-examination meant if they've given some imprecise meaning, or if the witness has a special meaning that they attach that might not have been apparent to the judge and left the wrong inference. If the witness has admitted on cross-examination to making a prior inconsistent statement, then you can bring out in re-examination the circumstances under which it was made, that they were pressured or they didn't understand, or that they had a reason for not telling the truth at that particular time. You can ask the witness if they understood certain questions that were asked. That's usually one of the marks of desperation in the re-examination. When you gave the case away, did you understand that question? You can ask the witness to complete an answer that was interrupted and therefore deprive the cross-examiner of the tactic of asking a question, the witness says, yes, but, and the cross-examiner says, I have my answer, thank you, and sit down. You can always ask the witness to complete that. If the witness is accused in cross-examination of having, inventing a story, that the story is a recent fabrication, then you're allowed in re-examination to bring out all the times that the witness in the past has told the same story, therefore establishing that this is an old fabrication, not a recent fabrication, therefore much more worthy of belief. One question you are entitled to ask, although it seems that it would almost always be folly to do so, is ask the witness to explain discrepancies between evidence in chief and cross-examination. So you ask your witness, well, when Ms. Davidson was cross-examining you said the light was red. You told me in chief it was green. Can you explain that discrepancy? And ordinarily you get the witness to say, well, I forgot which answer helped me, or something helpful like that. What you can't ask on re-examination are leading questions. Still your witness, can't lead them. You can't ask them to repeat or reiterate the examination in chief, and you can't ask them anything new, something that you didn't go into and that the cross-examiner didn't go into. So you stay away from any questions which begin, could you repeat, although that's often done, and you should stay away from questions that will elicit an answer, well, like I said before, because those presumably will incur the wrath of the judge. Now that's re-examination. Let me turn briefly to reply. Reply is the right of the plaintiff after the defendant has closed its case to call further evidence. And this is governed by a rule, can be expressed relatively briefly, that the plaintiff isn't allowed to split its case. In fact, the Supreme Court of Canada has given a decision on this point and has said that the same rules apply generally in criminal and civil cases to reply evidence, which is interesting on a sort of a side issue because the Supreme Court of Canada apparently works on the basis that there are rules of evidence that apply in civil cases, which is contrary to the view expressed by many trial judges. What the Supreme Court of Canada says is the plaintiff can't introduce part of its case in chief, part of its evidence in chief, let the defendant then put forward its points, and then try to bolster the case or lead more evidence in reply, and thus split its case surrounding the defense case. You've got to lead all your evidence in chief, everything you need to prove your case and everything you anticipate you need to deal with what the defense is saying. And then your reply is limited to new matters that you could not have reasonably anticipated. So reply evidence, proper reply evidence, is limited to explaining or contradicting evidence given by the defense, not confirming or buttressing the case you led in chief. And there's a few other points that on this that are important. Even if something new is raised in defense, if it was raised because you ventured into it on cross-examination, plaintiff's counsel decided that to discredit the witness, they'd venture into a collateral matter, not strictly relevant, but they thought it would be helpful for the judge to know that there was a break in the defendant's career when plaintiff's counsel thought the answer he was going to get was that the defendant was in jail, not strictly relevant, but may color the view of the trial judge. And the defendant instead answers, yes, that was the year I took off to go and pick up my Nobel Peace Prize. Well, because that's a collateral matter, you're not allowed then to lead evidence that in reply that in fact that evidence wasn't accurate. So you are restricted on collateral matters. You have to stay out of them in reply. You cannot call a witness in reply on the basis that you thought the defendant was going to call them. Now, it may be different if you have an undertaking from the defendant, but if it's simply an expectation, that doesn't allow you to call the witness in reply. It's sometimes thought that when there's a claim and a counterclaim, that the plaintiff, who's the defendant by counterclaim, has a full right of defense to counterclaim unrestricted by the rules of reply, and that isn't accurate. In fact, if the claim and counterclaim are mirror image, as they often are, then you are restricted, even in defense to counterclaim, by the same rules that would govern reply. In other words, you have to call your whole case in chief, including anticipating the counterclaim to the extent it's relevant to the overall issues. And that's what I know about reply and re-examination. Thanks.
Thank you. Next, Susan Gunter. She was admitted to the bar in Ontario in 1996. She practices at the firm of Dutton, Brock, McIntyre and Collier. Her practice involves insurance litigation, primarily in the areas of products and occupiers' liability. And her topic is on demonstrative evidence, sort of an update.
Hi, thanks for sticking around, you guys. What I want you to know is that I actually did prepare a PowerPoint presentation, which would be a demonstrative way to remind you about the law about demonstrative evidence, but I've decided, understanding that less is more, that because I'm going to try to keep my talk to under 3 minutes, it would just be overkill, and you'd see that I was just obviously trying to kiss up to the audience. So my paper is basically contains everything I'm about to say. It's sort of in a checklist format, and I know that almost everybody here is familiar with demonstrative evidence anyway, but what I want you to get from my brief talk is what's out there nowadays, and to try to remember a little bit about why it's so useful. First of all, demonstrative evidence helps the trier of fact, either a trial judge or a jury, understand the evidence. It allows you to communicate quickly what might take hours of oral evidence to explain in detail. It allows you to communicate graphically, which in fact might provoke some sort of an emotional response in the trier of fact. And it also allows the trier of fact to retain the evidence that's come out at trial more readily than evidence which is simply heard orally. And most importantly, demonstrative evidence, in my view, and I'm sure I'm not the only person who thinks this, demonstrative evidence, if it's done properly, just makes the lawyer using it look really good. And in all seriousness, I think nowadays, in the age of the soundbite, as we were talking about before, probably the most important thing, certainly at the outset of a trial or of a pretrial procedure, is to engender the confidence of the trier of fact. So if you look like you really know what you're doing and you're quite prepared and you have a PowerPoint presentation or some other type of technologically advanced presentation, I think that can really serve you in good stead. When I think of demonstrative evidence, there are sort of two categories. The category of real evidence, like a plaintiff showing a cast on her leg in the witness box, or a failed seatbelt mechanism, or the other category, which is sort of illustrative evidence. For example, in a personal injury action, a treatment chart which shows the amount of treatment that the plaintiff has had to have as a result of the injuries she or he sustained. Most of the laws regarding admissibility deal with the illustrative evidence category of demonstrative evidence, which is basically evidence prepared by the lawyer for trial. In my paper, I set out what the basic rules of admissibility are at page 16-3. What I think the most important thing to take from that is that the main test that the court will apply is this now very common test of whether the prejudicial effect of the evidence will outweigh its probative value. And with that in mind, and knowing that admissibility is, of course, entirely within the discretion of the trial judge, there are some factors to be considered, which I've listed in my paper, and I'm not going to go through now. The most important thing to remember, though, is if you have created some illustrative evidence, it's very important that all of the facts which go into that illustration be objectively supported in sworn testimony at the trial, and that your depiction of what the facts are at trial is accurate. With respect to the discretion of the trial judge, I might just point out that it's very rare that a court of appeal will turn over a decision of a trial judge with respect to the admission or the exclusion of demonstrative evidence, which is strictly for illustrative purposes. There are 5 main types of demonstrative evidence that you may use, including documents, videos, audios, computer-generated aids, and objects. I've listed examples of each of those types in my paper. I will not go through them now. But then at page 16-7, I've listed a bunch of presentation tools that you can use. In terms of equipment that you might want to be familiar with, if you haven't been to trial lately with a well-known plaintiff's personal injury lawyer, chances are you will not have seen this excellent new device called the Elmo, which is a visual presenter, and it looks like an overhead projector, except a little bit fancier. And basically, it's got a lens here that is over top of the screen, and it allows you to magnify whatever is underneath the lens. So, for example, if I want you to see the writing on the pen, I hold the pen underneath this lens, and the pen's image will be projected on the screen. So, or for example, if I wanted you to see my notes, I would just put the notes down on the screen, and that would be presented up on the screen. Or, more importantly, how about a failed seatbelt mechanism like I was talking about earlier in the example of a products liability case? If it's a small little object that you want to show to the jury, instead of handing it from one jury member to the next or asking the judge for permission, you can simply use this particular magnifying device to allow you to show the whole thing on a screen. So I think that's, in terms of what type of technology you might see in a courtroom nowadays, you should look into the Elmo if you're about to go into any trial which deserves the use of demonstrative evidence. Finally, when to use demonstrative evidence. I don't need to really talk about the fact that lawyers are more and more using demonstrative evidence at the pretrial stage, either at settlement conferences, pretrials, or mediations, or even settlement meetings, because Leilah mentioned it in her talk. I think it would be sheer folly to think that demonstrative evidence should be left until you know you've got a case that's not going to settle and it's going to go to trial, because let's face it, we all know most cases actually do resolve themselves at the mediation, and what can be more powerful than when you finally get all of the parties around the table to show your demonstrative evidence there. Of course, the downside to using your demonstrative evidence at a mediation is that the cat is out of the bag, and if you were hoping for a little bit of a surprise element with respect to the evidence, it's gone. Certainly, demonstrative evidence can be used at trial. I'm not going to mention that, although I do set it out in my paper, except to say that Scott Densen's point is right, that the law is a little bit confused about whether you can use it in an opening address unless you have consent of the other side. And what he didn't mention is that you have to let the trial judge know that you're intending to use the evidence. And generally speaking, I think it makes a lot more sense to have a voir dire for each type of demonstrative evidence that you intend to use at trial. Finally, at the end of my paper, page 16-10 and onward, I set out a 15-point step-by-step process which I've prepared for my own self, which allows me to sort of keep myself under control in terms of demonstrative evidence. And I think if you prepare your case early, and you isolate the issues you intend to prove, that you have to prove to win your case, then a good idea is to sit down with some colleagues, perhaps, or your family members, and brainstorm some ideas about how best to portray graphically or in an illustrative way the demonstrative evidence, the evidence that you have to prove. And as you go through my little checklist here, you can see, I think the most important thing to remember about it is that less is more, and I think sometimes counsel might tend to get a little excited about the technology that's available, but apply a critical eye in any event to the demonstrative evidence that you might use. And then the last few points of my checklist here just set out the steps to follow when you're at trial in terms of admitting your demonstrative evidence. Thank you very much.
Thank you very much. I'm going to ask our last two speakers to come up. The next speaker is Pamela Stevens. She's a partner at Hughes Amy's, was admitted to the bar in 1979. She practices in the areas of insurance-related defense, products liability, personal injury, and all aspects of insurance coverage, as well as municipal and environmental matters. And her topic is dealing with having someone declared a hostile witness.
Thank you, Andrea. As we all know, the best laid plans can go astray, and this happens in trials as in life. Nothing is more disheartening for trial counsel than to call a witness confidently leading his or her evidence towards A and then hear B come out of the witness's mouth. But it happens, and anyone that this happens to is to be consoled because there's a procedure for dealing with it. First, you have to have a witness who is actually hostile or adverse. There's been much judicial discussion about this. We know that adverse is not a witness who is suffering from what's been described as a defect of intelligence or memory, partisan bias, weak faculties of observation, or want of moral honesty or regard for the truth. That's what Justice Schrader in the Boland and Globe and Mail case that's referred to in my paper said. It's to be hoped that you wouldn't call a witness who had those characteristics in the first place. Adverse is the term that is used in the sections of the Evidence Act, and it's generally a broader term than hostile. I think we'd all recognize a hostile witness if we saw one, someone who refused to be responsive to the questions, someone who was argumentative with you, or someone who objected to answering questions. That would definitely be hostility. The cases say that adverse may include a witness who, though not hostile, is unfavorable in the sense of assuming by his or her testimony a position opposite to that of the party who is calling the witness. The result of having a witness declared hostile or adverse leads to the right to cross-examine the witness at large. And that's a common law right that still exists. It's not necessary to resort to the Evidence Acts, but the sections are there and they are what is commonly used. If you call a witness whose evidence at trial contradicts a prior statement that you have from that witness, then you can use the statement in two ways. You may first use it simply to establish that the witness is adverse. That leads to the right to cross-examine the witness on his or her evidence at large. Or in a more limited way, you can use the statement to prove that the witness has said something different before on that very issue, and then you cross-examine on that issue in the statement alone. Adversity is a question of fact in each case, so the cardinal rule is, as with most trial issues, be prepared. When the witness begins to demonstrate adversity, you have to ask the court whether you can address an issue in the absence of the jury. If there is a jury, the jury should retire, then raise the circumstances of adversity, including the existence of any prior statements by the witness. The judge will then likely hold a voir dire or a hearing within the trial with respect to the prior statement. And you, as well-prepared counsel, will of course have anticipated this. You'll have copies of the statement for everyone, the witness, the judge, the other parties. You will have just available at the back of the courtroom or outside in the hall the witness to the execution of the statement, who can give evidence to the fact that the statement was given on a particular day, that it was signed voluntarily by the witness, that the witness was not incapacitated in some way when he or she gave the statement. If there's a transcript or a videotape, then of course you'll have that too. If you have to prove a prior oral statement, it's a little more difficult, and you'll have to have witnesses available. They will be even more important because there will be a question of credibility if your first witness has actually denied making the statement. My paper sets out a number of cases, and the sections of the Evidence Act are in there that you'll need. Section 23 of the Ontario Evidence Act is the section to look at for the rule dealing with the finding of adversity. Section 20 sets out the procedure for putting a prior statement to a witness. So what use can you make of this statement once you have it? If the witness adopts it, of course, or admits it, then it can go in as evidence in its own right. And where the statement is given under oath before a witness or videotape, then it may be, you'll enter into an argument as to whether it's sufficiently reliable to be accepted as evidence in its own right. Be forewarned, your opponent is always going to object that there was no opportunity to cross-examine on the prior statement, I mean, there hardly ever is. If you send an investigator out to take a statement from a witness, you don't invite your opposing counsel along to cross-examine on the statement. That will be the objection, so you have to be prepared to argue that there are other indicia of reliability. Statement was given either under oath or that it was given voluntarily before witnesses, it was given with a full understanding of its effect. Those kinds of things will overcome your opponent's objection. Now, this is something that the police and Crown attorneys always run into, they've known about for a long time. For some reason, cases in which witnesses recant their testimony seem to be more common in the criminal sphere, and many a Crown prosecutor has been faced with an adverse witness. So because you've all sat here for a little extra time today, I'm going to end with a discussion of a case that is a criminal case. But as we all know, as civil litigators, the criminal cases really have the most interesting fact situations. And in this area, there is definitely crossover between civil and criminal law because the sections of the Evidence Act are very similar. And of course, the Federal Evidence Act, which applies to criminal matters, also applies to bankruptcy proceedings, immigration proceedings, and many federal court civil proceedings. I call this case the peanut butter case. It's R versus SH in 1998. It was a preliminary inquiry decision. The charge before the court was sexual assault. The complainant was 15 years old, and she alleged that her uncle had sexually assaulted her when she was age 13. So on the night of the incident, the police had actually been called, and they came to the girl's home. They interviewed her in the presence of family members, and notes of that interview and her statement at that time were taken, but she was not administered an oath, and she wasn't given the standard warning about the fact that what she said might be used against her. At some point later that same night, she was taken to the police station, and she voluntarily gave a videotaped statement to the same police officers. And then several weeks later, she wrote a letter about the incident in question to her uncle. The incident involved a food fight at home that had gotten out of hand and culminated with her uncle smearing peanut butter all over her breasts and vaginal area and under her clothes. So that's why the facts sort of stick in your mind. Now, when it finally came to the preliminary inquiry and the witness was called by the Crown, she was visibly upset, and the judge describes this. She was crying, she was emotionally shaken, so it was clear that while she might not have been hostile, there was a problem here. She answered all of the questions put to her by the Crown, but she simply denied that there had ever been any physical contact between her and her uncle, other than the occasional friendly hug when they were together. So the Crown applied under Section 9(1) of the Canada Evidence Act for leave to cross-examine her at large as an adverse witness. Leave was granted, and on cross-examination, the witness said, when the earlier statements were put to her, that she had lied about the peanut butter incident because she was mad at her uncle because he'd betrayed a family secret to her mother. She did not adopt her prior statements as truthful. So then the court had to look at these three prior pieces of evidence to determine whether they could be admitted as truth of the contents of those statements so that there would be a charge or not to proceed with. The first statement that was taken on the night of the incident at the complainant's home was found to be not sufficiently reliable to be admitted as evidence in its own right. There were notes taken, but they weren't very clear. There were no notes about the witness's demeanor. She hadn't been sworn. She hadn't been warned about anything. Now, then the videotape was the next thing looked at, and it was found sufficiently reliable because the judge was able to view the videotape, and he could see that that evening the complainant had been calm and relaxed. She'd been given a warning before her evidence was videotaped and it was on the tape. She knew that the evidence she gave could result in serious charges against a member of her family. Further, the letter that she wrote to her uncle, which specifically discussed the peanut butter incident, supported the reliability of the videotape. So, the preliminary inquiry, as far as the Crown was concerned, was successful, and it was found there was sufficient evidence to proceed to trial on the charges of sexual assault against the uncle. In this area, criminal cases can be instructive both with respect to the question of what is adversity for the purposes of the sections of the Evidence Act, and what safeguards are necessary for a prior statement to be accepted into evidence, even over the complete denial by the witness that they'd ever made that statement. So as with other areas of trial practice, the rule is be prepared. I wish for all of you that all your witnesses will be favorable, but at least you have the procedure to deal with if any of them are hostile or adverse. Thank you.
Thank you. Last speaker is Brad Hartley. He was called to the bar in 1987. He practices with the firm of Zarrett, Taylor, Grossman, and Hanrahan. Again, like many of our speakers today, insurance-related issues with a focus on property and casualty litigation. He has as well an appellant practice in these areas. And he is going to wrap up the day with a little information on how you actually arrange videotaping of trial evidence.
Thanks, Andrea. Given I'm the last speaker of the day, given the topic I'm dealing with, fortunately I videotaped my presentation, so if we can roll the tape, I'm going to leave. Honestly, I will try to be as brief as I can. I spent some time in regard to the preparation of the paper, specifically pointing out the exact provisions of the rules to be looked to in regard to this area of taking evidence before trial and the presentation of it at trial. The reason why to do it is relatively obvious, I think, and essentially it boils down to the very core question of when you have a situation where you have a witness who may likely not be available to give evidence at trial. The usual reasons being they're going to die in between the time that you're considering the question and trial date that's scheduled. They're going to be in such a poor condition of health, they're going to be incapable of giving evidence at trial when ultimately the matter is reached. And the second most common situation is where you have a witness who's anticipated to not be in the jurisdiction when the trial date arrives. The reason for that being relatively obvious, I think, as well, which is the court only has, of course, domestic jurisdiction to compel any witness to come before it, and if they're gone from the jurisdiction, you're going to have some difficulties there. I do not deal with in the paper, and that's not part of my presentation, the specific issues concerning when you're dealing with extra-jurisdictionally present witnesses. When you've got to go to the United States, you've got to go to Europe, you've got to go outside of Ontario to get a witness. I don't deal with that. That's another subject and especially altogether. The general rule is that any witness who is going to be presented before the court on behalf of a party to give evidence must be there to do so in person. The reasons for that are obvious. That way they're before the trier of fact, particularly a jury, to be seen, to be heard, and to be cross-examined in person, live, and present at that time. The exceptions to the rule are as prescribed in the rules, as you'll see set out in the paper, and generally come back to situations where you've got a witness who is in such a state of health or age at the time that the trial date is being contemplated that there is a real concern that when the trial is reached, they will not be either alive or available or capable to give their evidence at that time. And as I indicated, the other most common situation is a witness who is either now or more importantly at the time of trial not anticipated to be within the jurisdiction, so you just can't go out, serve them with a summons, and bring them before the court. The mechanisms for doing the taking of evidence in that fashion I've set out in some detail in the paper. They're all set out in the rules. How to do it is essentially prescribed by Rule 36. I encourage everyone to take a careful read of the rule if you run into these circumstances. Two methods by which it is done is one, on consent, and two, if you cannot get the consent of the other side, then you have to go get an order to do so. It's a discretionary order. There are certain indicators that the court is directed mandatorily to look to in deciding whether or not to exercise its discretion to grant such an order. How it is done essentially in the same fashion as any other method of taking evidence before trial, with one notable exception, which is because you're taking evidence which is anticipated to be presented at trial, it should be done in the same format, which means it should be done with a proper examination in chief, a cross-examination, and a re-examination if so advised. There's a transcript usually prepared of the examination, and particularly germane to the topic we're dealing with, it is also allowed that the examination be videotaped. The reason for that being, if you find yourself in a situation wherein you've got a witness that you obviously feel is important, but for whatever reason, health or the fact that they're going off to a nice exotic land and don't want to come back and give evidence on behalf of your client at trial when the matter is reached, you need to get that evidence before the court in the next best fashion to live. And the next best fashion to live, as we all know, is in the movies, which is by way of videotape. So the procedure is such that you would arrange for the examination either on consent or pursuant to a court order. If you're really lucky, you are involved with a client or a witness rather who is outside of the jurisdiction, so you may get yourself a nice trip to somewhere exotic and interesting. Conversely, of course, you might find yourself in the northern regions of Quebec having to take evidence in the middle of the winter in that fashion. I could say I've actually done that, which is probably why I ended up with this particular subject. With regard to the procedure, you will find in a practical way, there are a number of examiners out there now who actually will arrange for a specific setup for taking a videotaped evidence. They will arrange the videographer, they'll do all the work, which makes things a lot easier. With regard to how it's done, one of the most important things to remember is don't wear your best suit, get your hair done, because you're probably, as counsel, not going to be on the video. The focus is going to be on the witness, which is the witness that the court ultimately is intended to be seen and heard in the video when presented at trial. A very important point is the question of objections, because of course a judge is not presiding over this particular taking of evidence as they would otherwise be if the witness is live and in person before the court. If you have objections or the other side has objections, they have to be dealt with in some fashion. My recommendation, as it is allowed under the rules, is you've got your one shot to get the evidence from this person, especially when you're going outside of the jurisdiction. You've spent a lot of money on behalf of your client to arrange this, to get this done. Take the opportunity. If there's an objection raised, the most practical way to deal with it, which is provided for under the rule, is to allow the objection to be registered by whoever wishes to make it, but then ultimately let the witness answer the question so it's recorded and preserved, and ultimately at trial, the judge will rule upon the propriety of the question, and either that evidence is going in or it's not, but if it's going to go in, at least it's there, it's present, and it's been preserved. As I promised, I was going to be short. Some final tips for some of the more creative people out there. No, there's no audio editing allowed. You're not allowed to put a soundtrack into the video later just because you want to emphasize a few things. And you're not allowed to substitute witnesses. You can't have Mel Gibson or Sharon Stone stand in for any particular witness that you feel maybe not is delivering in the same fashion. My last practical tip, I've been there, make sure the room that you have arranged to conduct this little exercise is big enough. I can tell you, being in Montreal in a small room for an entire day with plaintiff's counsel sitting on a credenza next to me, so we were out of the picture, with the videographer, the stenographer, an interpreter, and a nice sûreté officer. By the end of the day, nothing smelled very good. Thank you very much.
Okay, the only advice I have is, where I have used it is I had a witness coming from Miami who just was going to be 10 minutes, and to fly them up and the hotels and stuff, it was actually cheaper, and we agreed to just videotape, you know, the sort of 2-3 questions, because it was actually cheaper to do that than to bring the person here with airfare and hotels and meals and all that sort of thing. Anyhow, it's been a long day. Thank you, everyone. And don't forget to pick up Leilah's paper, and we'll mail you Gina's.